Hello and welcome back. Today we're looking at California and the 2025 updates to the California Consumer Privacy Act, or CCPA, as amended by the California Privacy Rights Act. On September 23, 2025, the California Privacy Protection Agency approved new regulations expanding the CCPA's scope and adding new requirements on automated decision-making technology, cybersecurity audits, and risk assessments. The CCPA has long been a reference point for privacy laws across the United States, but these 2025 regulations really raise the bar for transparency, security, and consumer protection. So let's start with its scope. The CCPA, as amended, already applies to a wide range of businesses that collect or process the personal information of California residents, but the 2025 updates broaden that reach even further. So while the law already covers businesses collecting personal information from California residents, the 2025 updates now bring insurance companies into scope. So the same privacy obligations will apply to them when handling personal data not covered by the insurance code. One major update introduces rules around automated decision-making technology, or ADMT, and it applies to any technology that replaces or substantially replaces human decision-making. Businesses using ADMT for significant decisions before January 1st, 2027 must already comply, and those using it after that date must be compliant continuously. Consumers also gain new rights to opt out of ADMT and access information about how it works, the data it uses, and how the outputs affect decisions about them. Businesses must now respond to consumer requests to access and appeal ADMT no later than 45 days after receiving the request. Businesses must conduct and document risk assessments, weighing privacy risks against the benefits of processing personal information. And assessments must include the purpose of processing, the categories of data used, any safeguards that have been applied, and for ADMT, how the outputs are used in decisions. They must be updated within 45 days of any material changes to processing activities, and starting in 2028, submitted annually to the CCPA by April 1st. Businesses posing significant security risks must complete cybersecurity audits and evaluate how their programs protect personal information from unauthorized access or loss. Audits are required for businesses meeting specific thresholds, such as processing personal data of 250,000 or more consumers, or processing sensitive personal information of 50,000 or more consumers. The deadlines are staggered depending on annual gross revenue earned. So we've got April 1st, 2028 for any businesses with over $100 million in revenue for 2026. April 1st, 2029 for revenue between $50 million and $100 million for 2027, and April 1st, 2030 for those bringing in less than $50 million in 2028. The updates refine how consumers exercise their rights under CCPA. Businesses must offer at least 2 opt-out methods and confirm whether requests are processed, for example, by displaying an opt-out request honored on its website when an opt-out preference signal is being used. Alternative opt-out links must remain clear and visible, titled Your Privacy Choices or Your California Privacy Choices, when sensitive information is needed for additional purposes. Then consumers must be informed and given information on how to provide consent. The California Privacy Protection Agency retains enforcement authority and will oversee compliance with ADMT audits and assessments. So in summary, the 2025 updates bring stronger oversight for automated decision-making. They bring mandatory cybersecurity audits and annual risk assessments, and expanded coverage to insurance companies. These updates build on urgency for organizations to enhance transparency and security before the first deadlines arrive. So how do businesses need to prepare? First, they need to identify where ADMT is used and ensure that human oversight is being documented. Second, plan early for risk assessments and cybersecurity audits aligned with April submission timelines. And third, refresh consumer notices and opt-out mechanisms to reflect the new rules. Acting now positions your organisation to meet California's next phase of privacy expectations with confidence. And if you need any help operationalising these changes under the 2025 CCPA updates, you can talk with one of our compliance experts today.